Scoggins, thank you for stopping by today. If you want to come on forward, we will hear from you on House Bill 488. Yeah, that's fine. Come on in. It's great to see y'all today. Good afternoon. Well, I'm Chuck F. Stration. I'm standing in today for chairing the Gunter Subcommittee, and we have 3 bills on the agenda today. Working on getting some of our bills and sponsors on some of the other issues that we have, but looks like House Bill 488 is ready to go, and we have Chairman Scoggins here with us today. So, Mr. Chairman, at your pleasure, go ahead and present your bill.
Thank you, Mr. Chairman. This is House Bill 488. It's LC 412931. And this is the same bill we ran through last year. It went through the House and it went through the Senate. And the Senate changed the effective date. So it came back over to the House for us to vote on it again. And we ran out of time. The COVID and the busy day on the last day, we just ran out of time. But it passed overwhelmingly in the House. All this does is in 2019, all the constitutional officers' minimum salary brackets were raised up, and we left off the magistrate courts. And so we were trying to include the magistrate courts in that same bill, what we did last year. And like I say, we ran out of time. So I'm back this year with the same bill, the exact same bill. And this is my magistrate judge from Bartow County. This is Judge Brandon Bryson. And I'll be glad to let him speak to the bill.
Thank you, ladies and gentlemen of the subcommittee. I appreciate the opportunity to get to speak. Just to reiterate what Judge Scoggins said, Representative Scoggins said, this is the same bill that came through last year. I want to touch on a couple things. This is a 5% increase. This would be the first increase in 14 years for the magistrate courts. In addition to the 5% increase, this also rolls in the COLAs that have been given across the state into that base salary. That was due to the suggestion of ACCG. It would help with the calculation of these salaries. So if you look at the bill as it is now, the new bill, and the current statute as it is, you'll notice it looks like 5%, greater than a 5% increase. That's not the case. That's just what the COLAs actually rolled in. So that would actually show the actual salary with the COLAs rolled in and the 5% increase. I do have some calculations here for each one of you to see if you want to see how that works. And just to tell you a little bit about magistrate courts, I think everyone here is an attorney. A lot of this increase affects magistrate judges and chief magistrate judges, as well as the chief clerk. And this also includes the probate magistrate judges, those who serve as 2 roles. They were left out of the COAG bill. But magistrate judges, these are judges that were called 24/7, 365 days a year. So I'm very proud to sit here and represent them, even though I'm on local legislation. This does not affect me. This does affect many counties in the state. And so we've got judges who are on call in the middle of the night getting woke up to do your search warrants, to do your arrest warrants. Speaking personally, that's me sleeping on the couch so mama doesn't wake up and the infant doesn't wake up. My officers come to your house at 2:00 in the morning to get a search warrant signed. We hear the evictions. Chief magistrates are not only hearing cases, they're department heads. They're in charge of personnel. They're in charge of the budget. They're in charge of scheduling the docket. We hear abandoned motor vehicle claims, civil claims of $15,000, garnishments, county ordinance violations, personal property foreclosures, and the list goes on. It's a wide range. And oftentimes we are the front lines for the people. These people are not represented by attorneys. So we're not just hiding behind our chambers. We're having to come out and actually help these people, guide them through the process, and often creating the forms and instructional material to help them so they can have their day in court. And so I'm very proud to be a part of this and to support these magistrate judges. And I just ask for your support today. Just as a reminder, this is county funds, not state funds, as the question had come up last year. And I'll be happy to answer any questions that you may have.
Thank you, Judge Bryson, and thank you to the sponsor for your presentation. We have a question from Representative Wilson.
Thank you, Judge Bryson, for being here. You made a comment, and if you could just help educate this young lawmaker. You said that some magistrates have their salary set by local legislation, correct? But for
That's
everybody else, they would be affected by this bill.
That's correct. This bill only affects the base minimum salary, or those whose salary is based upon this base, if that makes sense.
I don't mean to put you on the hot seat here, but do you happen to know how many magistrates around the state have their own local legislation?
If I'm not mistaken, all the metro counties have local legislation. It's for the outside counties, and I'm thinking around 70, 80 counties may be affected by this.
Got it.
So we've got judges who are, these are full-time positions. And if you look at, the lower end, we got them making in the 30s and the 40s, and these are guys who are on the call, weekends, leaving Christmas morning to go do bond hearings at the jail. We do bond hearings, preliminary hearings, and those have to be held, nearly every day, because the inmate has to be seen within 48 hours. So it's nothing for us to have to leave our families, run up to the jail. There are actually some counties where they have a cot for their people at the jail. Some do electronic warrants like me. I just get a phone call waking up in the middle of the night. Luckily, I don't have to go to jail, but very, very deserving, hardworking.
Certainly well deserved,
Judges.
and I'm happy to support it.
No, our judges in Gwinnett County have the cots at the jail like you're describing, so I'm familiar with what you're saying. Very hardworking judges. Any other questions? I don't see any, but we did have a handout. It's a memo from the Council of Magistrate Court Judges expressing support for this legislation. So, Judge, there's formal support from the council for House Bill 488? Is that correct?
Yes, so there is, and we're actually behind this legislation.
All right. Well, thank you very much. Thank you, sir, and thank you, Chairman Scoggins. If you want to scoot down, we have one other witness signed up, and actually I see her online. Never mind. I'll recognize Deborah Nesbitt to speak to the bill.
Thank you, Mr. Chairman. Thank you for allowing me to testify today. First of all, let me say this has nothing to do with how much we like magistrate court judges or that they don't deserve a raise. At ACCG, we try to remain consistent on some of our guiding principles. And this is basically an unfunded mandate. It's now the third year that it's come forward. And we took a vote this morning with our policy council, and they voted to oppose the legislation. Again, it has nothing to do with the magistrate court judges per se. We know everybody's working hard, but that is the position that they took, was to oppose the bill.
Any questions for Ms. Nesbitt? All right, seeing none, thank you.
Thank you.
All right, anyone else who wants to speak to House Bill 488? All right, well, as we always do, I'll give you, Chairman Scoggins, the last word if there's anything you want to say about your bill before we entertain a motion.
Well, this is a fair bill, I think. This is just a bill that's trying to keep the magistrate judges in line with all the other constitutional officers. And I think it's just the fair thing to do. So I ask for your support on the bill. Thank you.
All right, I'll entertain a motion if there is one. Motion to pass and second. All right, any amendments, further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, it passes and it is on to full committee. All right, thank you very much.
Thank you.
Thank you, Judge. All right, next we'll hear House Bill 109. Representative Clark, if you want to come on up. All right, Chairman Clark, thank you for being with us here today. And if it's all right, maybe I can just highlight some of the differences in the substitute that's before us here. We previously heard House Bill 109 in subcommittee and had a pretty robust discussion from the witnesses that came forward. This bill that's before you today makes a few updates, and I can just walk you all through some of those updates. First of all, due to and I may have a conversation with you, Chairman, as we go along, just to confirm some of the information that's my understanding. But first of all, if you look at lines 19 and lines 23, the age range that would allow for cases of abuse after July 1st, 2015 going forward, this would extend the statute to permit suits until the victim turns 52, as opposed to 38, which was in a proposed draft, which was your original proposed draft. And that's consistent with the evidence that you cited to that 52 is the age, in fact, when many victims are willing and able to come forward to disclose the abuse. Is that correct?
Yes, sir. It's the average age based on research.
Okay. All right, and that then allowed us to remove a subsection that was below that was providing for a range from 23 to 38. So that doesn't appear here just because we've updated the dates. That will, in lines 19 and 23, that will address that. The next change is
I believe line 68.
yes, go ahead.
Based on some of the testimony during our last subcommittee hearing, changing the language on line 68 from resulting in to contributing to, just to clarify the intent of the bill versus holding up any kind of court judge ruling that it might, there could be a series of events that could have been kick-started off by an abuse, and the damages could have been a contributing factor being the sexual abuse that a minor might have had, not the sole reason for the damages.
There is also, due to some concern with the drafting of some of the waiver language, that is out in this. But maybe the most notable difference would be on line 71, which is a change of the date for this look back provision from going back to July 1st, 1988 to actually go to July 1st, 1973, consistent with the responsibility to report that was in Georgia law at that time. Is that correct?
That's correct.
All right. And from your research and your work on this over more than one session, do you believe that this is an appropriate policy?
I believe so, Mr. Chairman. I think when you look at the language from 1973, it encapsulates what we're trying to do with certain entities and organizations that could have contributed. So by failing to obey Georgia law.
All right. Any questions for the sponsor? Representative Reeves.
Thank you, Mr. Chairman. So I'm very familiar with this issue from a few years ago when it came through the subcommittee I was chairing at that time. And unfortunately, I wasn't at the last hearing that this committee had. But nonetheless, I understand this has probably already been discussed, and I don't think that I didn't know to ask you these questions before now, or else I would have come to you at another time. What happened that, because the way that I recall is that the previous look back period was based on the concept of mandatory reporting when those laws were put into place. And one of the things that I recall from 2018 in this bill was that the way that there was a mechanism, like, for example, the original mechanism in your bill was tied to the look back period from the mandatory reporting laws. I know that in the bill that I had worked on years ago, we, Chairman Golick at the time and myself, crafted what was essentially a new kind of very limited tort of a fraud that would be specific to the Hidden Predator Act, in that it replaced the element of detrimental reliance with the element of a concealment, and so therefore there was something very specific that that to me kind of justified what we did. And in your previous logic with the mandatory reporting dates, it kind of in a similar way was based on something logical. And again, I'm reading this in real person, and so, or real time, excuse me. What's kind of happened between where we were and where we are now? Because now it just, at least from my very, very quick and furious reading of this, it just seems that we've moved the date back, and there really isn't anything kind of qualifying as something that I would call a logical mechanism to be tied to it. Does that make sense?
So I don't know about the previous version back in 1718, but in 1920, when I began to work on this legislation, in conversations I even had with you, talked about looking at the code section of mandatory reporting, and when it was modified to a certain point, that it was clear that organizations should be, they were mandatory reporters. This happened, and you have to know that it happened and then work to conceal and cover up after they were a mandatory reporter. And I thought that that was a logical place in the law to look at. And I had originally put the 1973 date in there, and then last year through the committee process, it got moved to 1988. That's what passed out of the House last year, brought that same version of the bill in this year. And then these are some of the changes through the committee hearing we had, I believe it was last week, and then working with members of the committee based on those testimonies to come up and present this this substitute going back to the 1973. And so, but what was revealed in some of those conversations were that some of the victims who had testified last week in subcommittee, that the bill that we had with the 1988 date wouldn't even help them, even though they know there's documentation from organizations that work to conceal and conspire to cover up what had happened in their organization. It wasn't just that they turned a blind eye, is that they worked to cover it up. And moving it back based on working with some of the committee members was a way to make sure that the victims were trying to help have a voice and are able to seek the damages that I believe they are justly owed. So,
Mr. Chairman, I ask another question.
I don't know if that answers your question on as far as the logic of why we went back or not, but
and again, I'm very familiar with the issue and have, kind of lived this issue from a few years ago. What I know that the arbitrary nature of this is, and I remember this from a few years ago, I've got the scars to prove it. When you draw a line, there's always going to be somebody that is on the other side of that line. And July 1st, 1973, is there somebody on the other side of that line right now? I mean, what will we do when somebody comes forward and says, I'm on the wrong side of that line?
Yes, there will be people that are on the other side of that line. But I believe this date more adequately reflects that code section, that mandatory code section, it came into existence in 1965. It was changed in 1973. And I believe that change in 1973 is a logical point where, based on the language of that code section, and I'm sorry I don't have that code section in front of me right now, based on the language of that code section at that time, the organizations dealing with the duty of care for children, the way it's worded, would cover the victims. And then, yes, there will be people on the other side of that, but at the same time, I'm trying to work to have a logical point where you can say, hey, these, you can't argue that we just thought you could treat things differently, or that we were trying to seek the betterment of the victim themselves by not bringing this up and not reporting it and get involved in because the law said you had to report it. So trying to find a logical point where their action of covering up and concealing it is indefensible. And I think that 1973 version of that code section is appropriately a logical stopping point.
All right, any other questions? All right, we have one witness signed up, Carrie Silverman, who I believe is online.
Mr. Chairman, thank you for the opportunity to testify today. Can you hear me okay?
Yes, and I know we heard from you last time, Mr. Silverman, so just certainly anything that you want to add from your previous testimony, we'd be happy to hear from you now.
Thank you. I'll be very brief, Mr. Chairman. I'm here on behalf of the American Tort Reform Association. And as I testified last week, ATRA's concern with reviving time-barred claims is with any type of civil action. And we have no issue with otherwise providing more time to file claims going forward, so long as there is a finite period. I'm not going to repeat my testimony. I just registered to testify today only in the event that the substitute addressed those concerns or raised new or different concerns. My understanding is that the substitute bill revised claims now dating back an additional 15 years to 1973, which would allow the filing of claims about what an entity did or didn't do or should not have done nearly 5 decades ago. My only observation is that the longer the reviver window goes back, the greater ATRA's concern as to whether judges and juries will have the information that they need to witnesses and records to accurately determine liability. And we're concerned about the precedent that's being set here. So I thank you again for your efforts on this important issue and for considering our views.
Thank you very much, Mr. Silverman. All right, at this point in time, we will move forward with the committee's review of the bill. So I would be willing to entertain a motion if there is one.
Move to pass.
Right. There's a motion and a second. All right, any discussion or proposed amendments? Representative Reeves.
Thank you, Mr. Chairman. On line 52 in the definition of entity, we break down, institution, agency, firm, business, corporation, private legal organization, but then it says public or private legal organization. And if this has been discussed, then I understand, and I apologize for not being here, but have we drawn out what public legal organization includes or what it's intended to include? And I do not want to hold this up today or get into a unnecessary drawn out conversation, but maybe if there is a way, if potentially defining that could be beneficial, if this committee would consider, again, not something I'm going to be able to figure out today right now, but will the committee potentially consider defining that for clarity purposes at full committee?
Well, I'll put it to the sponsor now, or if he wants, maybe the two of you can, regardless of what happens to the bill today, you two can communicate, maybe get with legislative counsel if necessary, and update the committee on that at full.
Okay, great.
Sure. Was there anything you wanted to add about that, or you just want to
I'll just
discuss
handle that with him.
offline? Okay. All right. Any other proposed amendments, discussion? All right. Hearing none, we'll now consider the bill. This is House Bill 109, Committee Substitute LC 412994S. It's now before the committee. All those in favor signify by saying aye.
Aye.
All right. Any opposed? Hearing none, it passes unanimous. On to full committee. So thank you.
And I'll get
Chairman.
with Chairman Reeves.
Thank
or-
you. Yeah, if you all would get together and discuss that issue. All right, the final bill that we have on the agenda is House Bill 334, and I'll call up Representative Gullett. Yes. All right, Representative Gullett, it's good to see you today. So just to get just to update things here, the subcommittee previously heard House Bill 334 as introduced and heard quite a bit of witness testimony. And it's my understanding that as you sit here today, you've worked on a substitute, but you're asking that we consider the bill as introduced with potentially an amendment. Is that correct?
Well, so initially I did think that. I think I've been able to group in what I believe we can talk about specifically on the sub and do the same thing with what we're trying to do.
Great.
Specifically what we added.
If you would just give us the LC number.
Sure. It's LC 412981S.
All right. Thank you. You can go forward with your presentation.
Thank you. So members of the committee, thanks again for hearing this bill. There's a long list of stakeholders on this bill that's worked diligently to resolve the issues associated with the legislation. We're close to consensus and only have two issues that I believe were presently in dispute. The chairman has asked me to specifically point out those issues today in committee, and they are as follows. First, the community bankers provided a long legal review as identified a range of technical perfections, most of which are included in the bill. They did also identify a larger concern around making sure that non-compliance with less consequential provisions in the process did not invalidate the title. The resulting language is contained in lines 448 through 459 of the committee substitute. After inclusion of these lines, the provision was reviewed by title insurers who expressed a concern that, while well-intentioned, it will create more problems than it solves. In short, the concern is that it would need to be interpreted by courts on a case-by-case basis and result in both litigation and precedent that will significantly complicate land title in Georgia. And then I'm gonna read the next problem too, and then I have a person to go through the bill if that's appropriate, Mr. Chair.
Yes, sir.
Okay. So additionally, we have included language in lines 437 through 443 that was proposed by Greca to require real estate documents to be recorded by a Georgia licensed remote online notary. The State Bar has since expressed a concern by memo to the chairman that this language is inconsistent with ink notary statute and can result in title concerns for subsequent purchasers over constructive notice issues raised by recent series of cases. I think that's the Gordon cases. Both provisions have been included in the sub as complete within the relative line numbers I presented. This will allow the committee to easily include or remove them based on you guys' judgment. And I have given my commitment to all parties that regardless of the version that we pass today, we'll continue to work to find common ground and address these issues. And if it's appropriate, Mr. Chairman, I'd like for Nicole Booth of Notarize, if she's online, to go section by section of the bill. I think we didn't really do that last time. We talked more high level. The bar kind of did a little bit, but she can go section by section, and we can potentially address these two, I think, outliers that still exist.
All right, Ms. Booth, we'll recognize you now.
Thank you. Good afternoon, Chairman, Vice Chairman, and members of the subcommittee. My name is Nicole Booth, and I'm Executive Vice President of Public Affairs at Notarize. Today, I'm providing a section-by-section overview of HB 334, which includes the most recent substitute language. At a high level, HB 334 provides notaries commissioned in Georgia the authority to use modern tools to complete notarizations electronically, both in person and remotely. For our purposes today, we will focus on the remote aspects of the bill, as remote online notarization incorporates the same technologies necessary for an in-person electronic notarization, but adds additional measures in a multi-layered process that helps prevent fraud in the remote context. If you're following along on your on the bill text, on the original bill text, we'll begin on page 2 of the text, and then also again, I'll make sure to highlight where the substitute comes in. In section 1.1, beginning line 23, this will amend section 15694 of the official code of Georgia annotated, going forth referred to as the code, to give the Georgia Superior Court Clerk's Cooperative Authority, going forward referred to as the Clerk's Authority, the express statutory permission to issue technical standards related to remote online notarization, going forward referred to as RON. Section 1.2, line 34, this will amend section 4517-1 of the code to add definitions related to RON, including appear, communication technology, credential analysis, electronic document, identity proofing, remote online notarization, and standards. These definitions highlight the difference between electronic in-person notarization and remote online notarization. It also specifies that in the presence of means being in the same physical location as well as interacting by means of communication technology. This section lays out the necessary information to be included in a remote online notarial certificate. Section 1-3 or line 144, if you're following along on the introduced text, it's page 7. This amends section 45-17-6 of the code, which relates to the authentication of a notarial act by a notary public. Specifically, the amendment requires that electronic seal may only be used for the purposes of any electronic in-person or remote online notarization and for no other purpose. Section 1-4, line 170, amends section 4517-8.1a of the code to require a notary to digitally sign the exact name the notary has on their commission on any notarial certification in the case of electronic in-person or remote online notarization. Section 1-5, line 178 or page 8 of the introduced bill creates a new section of the code, section 45-17-8.3, which relates to standards to be adopted by the clerk's authority for the use of RON. Specifically, the clerk's authority must adopt standards for RON prior to January 1st, 2022. Additionally, the clerk's authority is permitted to confer with state agencies on issues relating to technology and security for RON, and is required to consider the most recent standards of relevant national bodies, such as the Mortgage Industry Standards Maintenance Organization, or MISMO, and the National Association of Secretaries of State, or NAS, when adopting RON standards. In addition, this section creates another new section of the code, section 45-17-8-4, line 191, page 8, which requires a remote online notary public to first be appointed as a notary public. Specifically, applicants that wish to become a remote online notary public must complete a course of instruction provided by the clerk's authority and pass an exam, and submit an application to the clerk of the county of the applicant's resident, which includes relevant information such as the technology provider the applicant will use to perform the RON. If approved, the superior clerk will issue the applicant a commission as a remote online notary public with a unique commission number. The commission term will coincide with the term of the original appointment. Additionally, section 45-17-8-4 allows residents of states bordering Georgia with a business or employment in Georgia to fulfill the process to become a Georgia remote online notary public. This section also creates a new section of the code, section 45-17-8.5, which outlines the information that a notary public performing RON must keep in their electronic journal of notarial acts, and additionally outlines requirements for the capture and storage of the audio-visual recording or the performance of the notarial act. This section requires that the journal is to be retained for at least 10 years after the date of the last notarial act recorded in the journal. Remote online notaries public are required to transmit the journal to a repository for retention. The remote online notary public is required to create an audio-visual recording of the performance of any RON. A copy of the recording is to be transmitted to a repository. The clerk's authority is required to consider guidance from MISMO and NAS when adopting these standards, as well as the National Institute of Standards and Technology, or NIST, on digital signatures specifically. This section also creates another new section of the code, section 45-17 or line 331, page 14 of the introduced text, which allows a notary public located in Georgia to perform electronic in-person notarization for an individual in the notary's physical presence. It allows a remote online notary public physically located in Georgia to perform a RON for remotely located individuals, with extra considerations for internationally located individuals. This section also creates another new section of the code, section 45-17 which lays out requirements for the remote online notary public to keep devices, digital certificates, electronic records, electronic signatures, and electronic seals secure, and other duties related to the security of these technologies. And another new created section, 45-17 or line 375, page 16 of the document of the introduced text. This outlines the steps and requirements for the actual performance of RON. This includes identity verification of a remote presentation of valid identification credentials, credential analysis, and identity proofing. Additionally, a RON that's compliant with these laws satisfies the requirement of any Georgia law that a signer appear personally before a notary, except for the creation of execution of wills and other testamentary instruments. This section also again creates a new section, 45-17-8.9 or line 405, page 17 again, which outlines the fee that may be charged for a remote online notary public, requires a remote online notary public to disable technology that affixes the notary's digital signature and electronic seal upon the termination of their commission, and further outlines it is a misdemeanor for any person to illegally obtain, damage, or delete the technology that affixes a notary's digital signature or electronic seal. This section also creates a new section, 45-17-8.10 or line 418, page 17, which reiterates Georgia law on the unauthorized practice of law that a Georgia licensed attorney must supervise a real estate closing for property located in Georgia. This section creates section 45-17-8.11, line 427, page 18 now of the original text, which authorizes public officials in Georgia to accept tangible copies of electronic documents as original. We now move on to the first area of the substitute, which has been added. The substitute says that the notary has to be commissioned in Georgia to attest or acknowledge a document pertaining to real estate in Georgia. It creates a new section of the code, section 45-17-8.12, which says a notarization is presumed valid even if the notary makes a mistake or fails to perform duty. This presumed validity does not apply when RON is performed by someone who isn't authorized or to prevent an injured third party from seeking a remedy. Section 1-6 or line 460, page 19. This amends section 45-17-9 of the code to specify that remote online notarial acts may be performed in any county in Georgia. Section 1-7, line 466, page 19, amends section 45-17-17 of the code to require a re-signing remote online notary public to send a letter to the effect to the appointing clerk as well as the clerk's authority and destroy or delete their official notarial seal. Section 1-8, line 475, page 20, amends section 45-17-18 of the code to require a remote online notary public who does not renew their commission upon expiration to destroy or delete their official notary seal. Again, this was added in the new substitute, section 2.1, line 482. The new substitute says, It amends section 10-1-15 and 10-1-393 of the code to state that presenting a residential real estate document for recording that the presenter knew violated that an unauthorized practice of law is unlawful. Section 2.2 or 2-2, line 528, page 22 of the original text, amend section 44-2-14 of the code to relieve the clerk of responsibility of inspecting an instrument for recording if the apparent signatures of both required witnesses and any required seals are present on or in the instrument. Section 2-3, line 538, page 22, creates a new section of the code, section 44-2-31, which specifies that a real estate document that is required to be witnessed can be satisfied if the witness is physically present with the signer or sees the signer electronically execute the document by means of communication technology. Section 2-4, or line 555, page 23, amends section of the code 50-18-72 to state that records consisting of an audio-visual recording of a RON are not required for public disclosure. And then section 3-1 and 3-2, line 561, page 23. Last, the act is effective upon approval by the governor or otherwise becoming law, that any conflicting provisions of the law are repealed upon this bill becoming effective. That is
Thank you very
reading.
much,
Mhm.
Ms. Booth. Any questions for the sponsor or Ms. Booth? All right, seeing none. Representative Gullett, if you wouldn't mind just scooting down, we have a few witnesses signed up and we'll hear from them now. Sure. So let's hear next from Joe Powell, who is online.
Thank you, Mr. Chairman. Glad to be with you all again. I'm appearing on behalf of the Fidelity National Title Group of title insurance companies that do business in Georgia. That's Fidelity National Title Insurance, Commonwealth Land Title Insurance, and Chicago Title Insurance. We're pleased to have the opportunity to be before you today. We did want to speak about the language that has appeared in the savings clause. I believe it's lines 448 through 459, where I think it's more than likely just, well-intentioned on behalf of the community bankers for what they have proposed, but they have provided an opportunity for a so-called injured party to seek the invalidation of a record or a transaction that relied upon an incomplete remote notarial act, or just any other remedy under state or federal law. And so, in most laws, that would kind of be general language, I believe, but when it comes to how notarizations are handled and the fact that those are a covered risk under title insurance, which we all are aware that, legal documents in a real estate setting are going to be notarized and attested to, that that leaves too much question as to what might happen there. And so it would be preferable, and we would ask that that language in the savings clause be struck, not be passed by the committee, not be considered as part of the law. We don't want to start out the gate if the RON legislation is passed with a law where there's too many questions to begin with. You wouldn't want to have Georgia to be in a situation where, unlike other states, where the RON notaries end up being uninsurable for title insurance purposes, or whether it becomes just that flat exclusion. You wouldn't want that to happen for Georgia. So we appreciate the opportunity to share that point of view with you. And thank you.
Mr. Powell. Mr. Powell, so your proposal is to remove the proposed 45-17-8.12 from the bill. That's lines 448 to 459. Is that correct?
Yes, sir, Mr. Chairman.
All right. Does the sponsor have any response to that? Or maybe if the community bankers are in the hall, we can ask if they'd be willing to comment. But Representative Gullett, anything you want to say about that? You can use that microphone right there.
I'm not opposed to that change. That's really, I believe, I've gotten this to a pretty technical point that I'm not a closing attorney. It's not my wheelhouse. And understanding this, I'm a technology guy. So if that's the will of the committee, I support it. I think it's friendly if that's the will of the committee and what you guys think is best.
All right. Well, what we have two other witnesses signed up, but I can hear in the hall that they can hear this proceeding taking place. And if anyone from the Community Bankers Association, State Bar of Georgia, Georgia Bankers, or any other organization wants to give comments on the substitute and specifically that proposed change, we'd be happy to hear from you. All right. Thank you very much, Mr. Powell. Next witnesses that we have on the same line here are Joe O'Kelly and Kate Hoskin. They're here in person. Great. Come on in, please. Thank you. Yeah, if y'all want to come on up here and have a seat. Yes, that's fine. Yeah, if you would please take any time you need to get comfortable and then state your name, and we'd be happy to hear any testimony that you have for us.
Not really prepared for that, but we'll try it. So. Okay. Ready?
Well, we had you down, Mr. O'Kelly, signed up to speak to the substitute today. I know that there's kind of a new substitute that was put out, but committee be happy to hear any general comments that you have about the legislation. And certainly if there's nothing you want to share, don't feel obligated to say anything, but we just had you listed on the witness list as wanting to speak.
Yeah, I appreciate it. I got a call this morning and I've been thinking about this bill for a while, and I really thought through it, and I looked at it and I'm like, we're the largest closing attorneys. We got 60 attorneys, we got 220 people. And I'm like, really a Ron statute, it makes a lot of sense, but the way that this is being delivered and the sponsors, not Mr. Goet, but really who's backing this has really, I play in the national business in a lot of ways. And I really know what this is about in the way an e-closing bill is the way I call it. Okay. And so I look at it and the way a Ron statute works is in most states, 87% still want to have in person, but this is going to be pushed down. And people on a national scale in the real estate business, especially the big players, the financial technology companies, the property technologies, the prop techs, fintechs, and even the national title insurance underwriters, they want that vertical transaction. And so when you have a company like Zillow and you have a company like Notarize come in and sponsor a bill that was originally intended just to be, hey, sign this notary for building permits or something like that, and it explodes into Ron legislation, which was passed by or prepared by ALTA mostly, which is the American Land Title Association. And so when you see that happening and you know what's going on the national scale, you can see that really this is the camel under the nose, right? Under the tent, camel nose under the tent, in the sense of once this notarization, remote notarization comes along, it won't be too far once lenders come along with e-closing. I can tell you with this current, every article, I could bring 20 of these articles, right? That everything about it is, as soon as this passes, as soon as it goes into effect, I probably have 50 people that would not be working for me because they would do the e-closings, and I can tell you exactly how it all works, but they would do the e-closings that aren't required for the lenders. But once the lenders do come in. So am I being a protectionist? Well, we got 220 people. I got a lot of mouths to feed, and I won't be able to feed them if out-of-state factories, people, can basically come in and perhaps rent a Georgia lawyer the way it's designed. Literally, that's what refinances do. We've lost an entire refinance industry. The state bar won't enforce it. They'll say as long as the lawyer's in control, the lawyer doesn't even have to do really anything except, yeah, I'm in control, it's good. All the processing is done from out of state. And so I've seen it happen in the refinance industry. It's about to happen in the purchase industry. You have some company, I'll just use Zillow as an example since they're the big backers here. They buy the home, they list the home, they set meetings for the home, they have their own home loans company, they come in and get title. So they're going straight down the line and they want a little piece of everything. Then pretty soon Zillow or Open Door or any of those large companies, they'll have their own title insurance industry too. I'm not sure why the title insurance companies, maybe they think they're stronger, I'm not sure. After they close it, they'll get a moving company. I mean, they'll just have all of these. So it's up and down the line. And all this does is literally open the door. At the camel's nose is under the tent. We've opened the door and said, come on in. And literally it was nothing more, from what I understand, is a way to do remote notarizations, which we already have in place. The governor and the Supreme Court, the Chief Justice, they've put in place something that we've been using for 10 months and it actually works. And we can record those things. There's nothing about notarization that we don't do now that was originally intended. We could do it. We could even do it electronically without the need for third-party authentication. All of this fraud and third-party evidence, we've been doing it for 10 months. That's really just a smokescreen. So a lot of this is smoke. The details of the bill, lots of smoke. I'm not against Ron, but what I am against is we basically are taking what I thought was the law in Georgia, which was the closing attorneys intended to be in control and be the people who actually are watching the closing and managing the closing, right? And so within 5 years, small lawyers pretty much gone. It's just annoying just to get signed up with Ron. Large lawyers like me, we'll do it. We'll be fine because there's some local presence, but we'll be half the size. In 2 years, we'll be half the size. And so I'm looking at it and I'm more than happy to answer lots of questions. But I'm looking at it like, if we're really, Georgia is intended to be a closing attorney state, and there's only 6 of them, all right? Then what this does is allows other groups of people, nationals that come in, and they will rent a Georgia attorney. They'll start out with $100 a closing, and then they'll get it down to 25 because they'll say, what do you do? Which is nothing. They don't pre-close it. They don't get it ready. They won't do anything except say, oh yeah, I was in charge of that whole thing. And I've had numerous other national title companies come in and ask me, let me do all the work and we'll pay you a fee just to sign it. And I'm like, you're crazy. I'm not going to sit there and take your work, right? Now, arguably you could have everybody remote and you really could be in charge, but that's generally not the way it works. It sounds good in theory, but that is not what would happen. So I'm not a good speaker. I read this and I'm like, 31 states have passed remote online notary laws allowing digital closings to take place. That's from Notarize. Don't blame Zillow, blame your leaders. I've had Rich Barton's quote right out of his mouth. We want every piece of the transaction from start to finish. I mean, this is like, I don't even know why people aren't talking about that as far as from our perspective. Remote online notarizations can, and I've been all, I mean, we'll just, I guess we would just have to expand and take other people's business in Georgia. Not that I want to. I don't want anything like that at all. But I know how to set up it. I know what I would do. And I would just become a national player all over again. We sold one, we'll create another one and sell it, I guess. But what's happened is literally we are opening the door for an industry to be cut in half and then shrunk even further. And it won't be very long. And I felt like I had to come and say that because I'm not sure why we as an industry and lawyers are going along with the way it's happening, right? So again, nothing against remote notarization, right? We do that now. Nothing against third-party authentication, but let me do it. I don't know. I can't remember my my first dog. I can remember my mother's maiden name. I got that. But my first dog or my first car, I mean, it's insane. When we do a closing, we literally sit there and we look at the person and we look at their driver's license and we have a sense of whether it's fraud or not. And so if you're trying to do that portion of it to prevent fraud, well, fraud can go on without that now. Maybe it enhances fraud by giving them a remote electronic ability. Well, somebody will just sign it and mail it in to somebody who's going to commit fraud and they'll just stamp it and move on. This is, that to me, that's all smoke. It's all smoke, right? This is an e-closing bill. And I can't, and what we're going to do is in 5 years, 3 years, we're going to go, oh yeah, look at that. We just sort of opened the door for them. Didn't mean for that to happen, but that's what's going to happen. And so if anybody says it's not, sure, they'll say it's not. Oh no, we're not going to do that. You hear that in the news all the time. And I love fintech companies and I love prop tech companies. I do a lot of business with them, but they're a business. I'm not saying they're doing it wrong, right? Or it's bad, they're a business. Why wouldn't they want to do all that? But why would we just open the door for them when our real intent, I think in the Georgia, is to have closing attorneys be in charge? And we're the best, I think, people to do it, as opposed to national companies that have a little bit of presence there and do most of it remotely. So, sorry, took too long there.
No, not at all. And this is the kind of testimony we need when we're hearing big bills like this with major implications. So at this point, we generally turn it open for any questions. Are there any questions from members of the committee? Mr. O'Kelly? All right, hearing none. Thank you so much for taking the time to be here today and to offer those questions. And I know you provided your contact information when you signed up for today. So if any committee members have questions, they can follow up with you there. So thank you. All right. So what we'll do now is
I was hoping to get a lot.
Thank you. All right. Earlier, I had asked if a representative from the state bar would be willing to speak to the substitute, and Amy Huskins is on Zoom. Ms. Huskins, if we could recognize you at this time.
Sure. Can you hear me?
Yes, ma'am.
Okay. I'm sorry, I don't have the new bill in front of me, so I'm just going to speak from what I believe the language is that was sent to us over the weekend. And so you had asked, we have been contacted by your committee over the weekend. Rob Brandon, my co-chair, is on as well, regarding our understanding of the addition that is proposed regarding an express prohibition against an out-of-state remote online notary notarizing a Georgia real estate document. It's very limited, but it is an express prohibition. And so last week, when I testified before your committee, we briefly mentioned the Gordon line of constructive notice cases. And so we were posed the question over the weekend. We didn't volunteer this information. We were asked by your committee to provide to you our understanding of how this new insert that was not in the bill last week, but is in the substitute bill, might affect the Gordon line of cases. And so very generally, we spoke with some of the state scholars on this issue who know a whole lot about this. And just so that everybody just to recap very generally, as most everybody recalls, the Gordon line of cases arose from some bankruptcy cases with bankruptcy trustee Neil Gordon. And the original line of cases went all the way up to the Georgia Supreme Court. It started on the bankruptcy courts. It was certified to the 11th Circuit, and then was certified over to the Georgia Supreme Court. And what the fact pattern was, very simply, was that there was no unofficial witness on the mortgage document and no notarial seal. And those are absolute black and white requirements in the recording statutes that we've had in our state for many, many years. And so the closing attorney should never have allowed this document to be sent to the clerks for recording. The clerk should never have recorded these documents, but they got recorded. And so all the way up to the Georgia Supreme Court, the holding was, and there have been two of these cases, by the way, it's Gordon 1 and Gordon 2, that these were not deemed constructive notice because they were black and white patent defects to the recording statutes. And therefore the mortgages themselves were declared invalid and the lenders lost their collateral. So we were asked the issue over this weekend with this additional requirement of having a black and white requirement in this new statute of a remote online notary from out of state not being able and prohibited from notarizing a Georgia real estate document. Could that possibly create a new potential Gordon issue as a new patent defect? And our initial research in speaking with several people who do know a whole lot about this is the answer is yes, possibly. Because, for example, right now, as most everybody knows who does any kind of real estate law, there is an allowance, a specific express affirmation in the current recording code sections that a wet ink signature, notarization on a wet ink signature by an out-of-state notary, for example, somebody from California who's a notary, does a wet ink signature notarization, that is allowed, specifically black and white under our current recording code sections. And so there might be an inconsistency, not an inconsistency, a misunderstanding, sorry, regarding which document type is this and should they be recorded. And so to our knowledge, this new express prohibition is unique to Georgia. And we were, and so as a representative of the state bar, many of you who are members of the state bar know that we have to present statutes to the Board of Governors of the state bar. And our official response is we are neutral on this addition, but we were posed this question. Thank you.
All right, very good. So just so we're all clear, it's my understanding that the lines referenced that Ms. Huskins is referencing are lines 437 to 443 of the substitute that's before you here. Representative Wilson.
Say those line numbers again.
Yes, 437 to 443.
Okay.
And while you're looking at that, Ms. Huskins, is it your opinion that, do you have an opinion as to what should be done with this part of the bill in order to address the issues that have been raised, and have you communicated that to the sponsor? So if it's language that was added into the legislation, is it your view that if it's removed and changes are corrected elsewhere to make it fit, that would address the potential concern that you're raising?
I'm going to partially answer that question because we were not posed that question specifically. I will say that there was some discussion at the end. I'm talking about 3 days ago. This is a very tight time frame, okay?
Yep. So
the savings clause, for that, to use that terminology, that the community bankers proposed over the weekend, the state bar has many concerns about. And my understanding is that savings clause was perhaps partially intended to respond to this insert that Greca has proposed. And we are concerned about the savings clause as well. So at this point, the State Bar of Georgia officially does not have substitute language to the substitute language that would respond to these concerns. However, that said, the State Bar of Georgia, as I mentioned just a minute ago, is neutral on the insertion of the Greca language. We, however, do have major concerns with the savings clause language.
All right, Representative Wilson.
Ms. Huskins, I don't practice real estate law, so I have a couple questions. Just trying to make sure I understand what your testimony was. You talked about under current law, an out-of-state notary can do a wet ink notarization. Is that only if they are if they have a notary license in Georgia?
No. So in pretty much every state, currently, if there is keep in mind that every state's laws regarding the licensing of notaries requires that a notary public, let's pick the state of California for a moment. Let's assume a licensed California notary has to be sitting in that state to do the notarial act. And so let's assume that's the case here. And so if a California notary has a signatory in their presence in the state of California, and the signatory signs the document in front of the California notary, and that's considered a wet ink signature, correct? You follow me so far? Mm-hmm. And then that is then, because it has to do with the Georgia real estate property and needs to be recorded in the Georgia real property records, that is effective and it's accepted from any state. This is a new provision that that is unique, that would not allow let's say a California notary, in my example, to notarize a real property document regarding property in the state of Georgia. Keep in mind, because of a Ron statute, and this is the same across the country, no matter where you are, including our proposed bill, that the notary needs to be in the state in which they're seeing this person sign on a camera, if that makes sense. But the person, the signatory, can be anywhere. They don't have to be within that state, they don't have to be in the state of California, if that makes sense. So this is the difference.
And would this override that and prevent? Well,
No.
this wouldn't change in-person notarization, correct?
This is typically to do because there are heightened requirements, et cetera, if you're dealing with a remote online notary. Okay. My understanding is this does not change at all a wet ink signature documentation.
Okay. Thank you, Mr. Chairman.
All right, very good. What I'll do is I'll call on you, Representative, to just give us any final statements that you have. We have another subcommittee in here at 3 o'clock, so it's clearly we're not going to have time to be able to take up the amendments that appear will be necessary to discuss for the bills. So why don't you give us just a couple minutes of any final statements if you have any, Representative Gullett.
Thank you. So I think the final statement is there are a number of parties who want to see this bill done. I think before it was kind of portrayed as this is a notarized bill. This is a bill that I dropped last year that wasn't ready. Notarized had never reached out to me. Zillow had never reached out to me. The chambers behind it wants this bill. Greca is neutral to the bill. Greca is the Georgia real estate closing attorneys. They're neutral to the bill. And at the last hearing said that there's some obstacles there, but they want to see a bill done. And they gave us a couple of things that they wanted changed, and they were not against the bill. So just in saying that, I don't want us to portray that this is a vendor bill that's trying to get anything done in Georgia. This is something that my county IT person came to me, and we were working through our business licensing and said, hey, it'd be great. You're an IT guy. It'd be great. Why do we still have a traditional notary? There's got to be a way to do this differently. And lo and behold, once I Google it, there's a bunch of other states that already have this. So I just want to make that statement. And as far as the changes, I'm absolutely amenable. I think only person who wanted that section for the community bankers was the community bankers. The credit unions were good. The Bankers Association was good without that language there. So I think they were just, they had a different perspective. But outside of them, I don't know that anyone else wanted that provision in there. But like I said, I'm happy to get back to the front of the committee and just figure this out. And I can work in between then to try to figure this out. Of whatever you want me to do, work on a sub or work on amendments or however.
Well, thank you for your presentation today. My recommendation will be to communicate with some of the advocates who wanted the specific sections that were cited to today and try to work through any of the concerns that were discussed. And if any members have specific concerns, maybe you can speak with Representative Gullett directly so that can be voiced and we can make good use of time if and when this bill is to come back before the subcommittee or full committee. All right. Thank you. We are adjourned.